Yeah. Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39406, Coalition for Clean Affordable Energy versus New Mexico Public Regulation Commission. Can I have entries of appearance, please?
Good morning, Your Honors. Jason Mars appearing for Renewable Energy Industries Association of New Mexico, Allen, and also arguing today for Coalition for Clean Affordable Energy. Good morning, Chief Justices. On behalf of Public Service Company of New Mexico, Miguel Stratford Law Firm, and Stacy Goodwin, Public Service Company of New Mexico.
Good morning, Erin McCullough on behalf of the Public Regulation Commission. Good morning, Mariel Lanassi on behalf of New Energy Economy.
Good morning, Gideon Elliott on behalf of the New Mexico Attorney General's Office.
Keith Herman on behalf of the Albuquerque County Water Utility Authority.
Thank you. All right, Mr. Marks, it appears you have divided your time 14 minutes and 10 minutes.
Yes, Your Honor, and Chief Justice, we have an appearance from my colleague, Ms. Lynch.
Apologies, Kara Lynch with Coalition for Clean Affordable Energy, here with you.
All right, thank you. So again, confirming, hang on, let me do my thing, Mr. Marks. Let's see. You want 14 minutes for your argument in chief and 10 minutes for rebuttal. I'm trying to confirm that.
Yes, Your Honor.
Okay, and your ceding time to Mr. Alvidrez of 6 minutes. And Ms. Lakoki, 15?
Yes, that's right.
And Ms. Nanasi, 15?
Yes, Your Honor.
Okay.
But I will be going first.
All right, Mr. Marks.
Good morning, and may it please the court. This appeal presents two issues, both of which are questions of statutory interpretation. I will be addressing the first question, which is whether the legislature did in fact mandate the PRC to allow the rate mechanism known as full revenue decoupling. Mr. Alvidrez will follow me and address the dispute as to the application of the subsection 5F4 to utilities weighted average cost of capital. In 2019, the legislature amended the Efficient Use of Energy Act to add subsection 6217, 5F2, reading in pertinent part. The commission shall, upon the petition of a public utility, remove regulatory disincentives through the adoption of a rate adjustment mechanism that ensures that the revenue per customer approved by the commission in a general rate case proceeding is recovered by the public utility without regard to the quantity of electricity or natural gas actually sold by the public utility. Full revenue decoupling is the term of art for a rate adjustment mechanism that ensures a utility recovers its approved amount of revenue per customer without regard to the volume of sales. There's no dispute in this case that Section 5F2 describes full revenue decoupling and no other rate design mechanism. There are no arguments before the court that the meaning of any of the words in subsection 5F2 are ambiguous. Instead, the PRC and intervener appellees argue that the court should not give effect to the plain language of the subsection because it leads to a supposedly absurd result.
So, Mr. Marks, in light of your argument that it should full revenue decoupling means full, this idea that the overarching theme of all of these regulations, the balancing of the customer's interest, the industry interest, the investor interest, and the like, can that happen in light of full revenue recovery?
Yes, it can.
How would that happen? Give me some more examples.
Okay, and sure, Chief Justice. One of the things that you never see in appellate's briefs, but it's important to recognize is full revenue decoupling is a symmetrical mechanism. Sometimes if sales are higher than expected, the utility is going to refund money to its customers or credit it. If sales are lower than were projected in the rate case modeling, then the utility gets the ability to collect some money. The amount that's collected is actually not all that great. Decoupling adjustments typically run in the range of 1 to 2%. So we're not talking about a major change in how rates are done. It's, as will explain, or I can explain now, it's not that different from other things that the legislature has done. Years ago, the legislature severed the connection between fuel costs to the utility and the utility's profits. So the utility no longer would lose money if fuel was more expensive. It was a factor beyond its control. The sales, the volume of sales, in many ways is a factor beyond the utility's control. The biggest impact that we will see if we have full revenue decoupling will come from weather. If it's a hot summer, a hot spring and summer, sales are higher. If you read the financial page in the journal, you'll notice when there's a hot summer, P&M makes more profits. When it's a mild year, they make less. It'll sever that connection. Utility has no control over weather. And one of appellee's arguments are that the legislature did not intend for these broad impacts. They only wanted to address the disincentives to energy efficiency. It's clear, though, the legislature knew what it was doing. The language in this section is very clear. There is no way to give effect to the plain meaning of these words and not have full revenue decoupling. Nobody's argued. And
what about this argument that to hear that if we go your way and say that there should be full compensation based on the statutory language, that then the PRC is put in the position of just rubber stamping
the outcome. What do you say in response to that?
Well, first of all, it's like the legislature made the choice. And the legislature has the ability to change the rules of the road for utility regulation. But they did not put the PRC in the position of being a rubber stamp. In fact, when this case began, it began with a different case. The law changed, PNM filed for a decoupling adjustment, and CCAE and my client, we intervened in that case and we opposed what PNM proposed because it was not, we didn't like the specifics. Particularly, they picked a base year that was very and unfairly advantageous to the utility versus customers. And we were prepared to argue that decoupling is okay, and it's what the law says, but this particular proposal is not approvable. The PRC exercise your judgment, fix it, fix the base year so it's appropriate, fix the mechanism for collection so it's appropriate. And so in fact, the PRC does have that ability, the ability to not necessarily approve what a utility proposes, but they can't reject it just because it is full revenue decoupling. And that's
So,
what the commission did.
Stick with me on this one.
Sure.
So this is gonna be very, elementary school justice explanations. But at the rate making stage, all of these competing interests are considered before the rate is set. Is that a fair 60,000 foot statement?
Not really. A lot of it.
So the PRC isn't balancing the consumer's interest versus the public versus the investors pursuant to.
Madam Chief Justice, they are on some things. For example, the issue that frequently winds up here is the rate of return on equity. And that is an art and a science. There's balancing, there are different ways to do it.
So balancing has happened before the rate making stuff, in some fashion.
On some issues. There's some issues
No,
where,
just following you to some.
yes.
So then we get to the point where there are, arguably facts present that would trigger the statute and suggest decoupling needs to happen. Now, what if that gap that's trying to be covered is the result of something that is, from a policy perspective, unfair? Can, in looking at full compensation, say, okay, we're gonna say the number's 100, but the PRC then can say, but this piece of that 100 is because we made an error in the original making that was, anti-consumer or anti-investor.
That's a scenario I hadn't thought of. An error in the original rate making. Under our laws, there's no retroactive rate making. If the commission makes an error and it's discovered, and it would be unlikely because we have all these parties coming together. But if there was an error, you'd have to come for a new rate case.
So is it your position here that when we get to the triggering of 62-17-1-5, or I guess 62-17-5F, that the PRC has no discretion? They just have to buy what you tell them and say, yep, it's, say, I'm using big numbers, but it's $100. You say it's $100, so we're giving you $100.
Not at all, Your Honor.
Where does the discretion live in the PRC?
What the legislature said is, PRC, you cannot reject this just because it is full revenue decoupling. If a utility asks for full revenue decoupling and in its appropriate application that is otherwise fair, you approve it. If it's not otherwise.
How do they determine whether it is otherwise fair?
I'll go back to the example I was discussing. PNM came in and they wanted the base period for revenue decoupling to be 2015, and this was in a 2019 case. That's just not fair. It's not accurate.
So they can tinker with the numbers that go into the equation.
they can, and they can make sure that the math is correct. They can do a lot of things. They can make sure that the mechanism for paying out credits and collecting credits is fair to customers and to shareholders and doesn't produce extreme results. But what they can't do is go against what the legislature said was the policy. In our state,
Start with a smaller number right out.
yeah, you can't say, I'm rejecting this whole concept. And that's what the PRC said. The PRC said, full revenue decoupling has bad impacts or has broader impacts than just mitigating the disincentive to energy efficiency. And so therefore, the legislature couldn't have meant to do it. Well, they told the legislature that in the FIR for the bill. I think it was HB 291. They told the legislature, and I quote, if I can find it here, if you do this, you'll be shoehorning the commission into approving a decoupling mechanism under the guise of regulatory disincentive removal application pursuant to the EUEA without considering a wide-ranging implication of such a mechanism.
Council, could the PRC come back and say, we don't like your decoupling application. We don't think that the fixes being suggested are gonna fix it or are appropriate. Can they at that point say, you need to file a new rate application?
Justice Vargas, exactly. I mean, that was our position in the case preceding this one. Refile it, you can do that. The commission still has its expertise. What it can't do is say, we're not going to approve it because it's decoupling. They told the legislature in 2019, if you approve this, it's going to lead to decoupling. Decoupling is going to make other changes. It's going to normalize for weather. It's going to normalize for economic downturns and upturns. And don't do it. The legislature decided to do it. They knew what they were doing. And then the PRC comes back and says, well, it does these things. The legislature couldn't have meant to do that. The legislature did mean to do that, and it's within the legislature's prerogative. It's not the PRC's or this court's prerogative to make policy. It's with it or to,
Go ahead.
they have to work within what the legislature said. And when the legislature says something explicitly, you got to work within that.
But it's not a question of that a utility files an application for decoupling, full decoupling, and that the PRC has to rubber stamp whatever is submitted. Because as I read it, it's in a general rate case, and the PRC still has to take into consideration under F1, the public interest, consumer's interest, and investor's interest in approving or disapproving a proposed decoupling.
Justice Villa, I would agree. You know, as you all know, or maybe most of you know, I was a PRC commissioner, and I lived in that world. And you live in a world like every agency, circumscribed by statute. And there's a range of things you can do within statute. And we were elected, so we had some policy discretion, but you can't cross these lines. And when the legislature expressly says you shall approve a mechanism that allows the utility to recover the same amount of approved revenue per customer, irrespective of sales, you can't just ignore that. You can make it fair within those bounds, but you can't say, well, we're not going to let this mechanism, we're not going to approve this mechanism because we don't like the policy.
And in my question, I forgot to leave out the fact that it's also a function of ensuring fair and just rate of return.
It is, and as I told Chief Justice Bacon at the beginning, this is not upending the regulatory compact. This is a tweak. It doesn't result in huge changes. It does have benefits. There are reasons why a utility might want it and might not want it. It's symmetrical. Customers benefit under a lot of circumstances, and it does implement the state's policy. The state's policy is to encourage energy efficiency, and this makes a utility agnostic to how much electricity it sells. Without decoupling, the utility makes a profit by selling more, and this legislature wanted the utilities not to care. and I'm. Thank you.
May it please the court. I would like to follow up on some of the questioning that the justices just posed a few moments ago. And that is, I think, to put this in perspective, this is not a sea change by any means. All it really does, all the amendments to the Efficient Use of Energy Act does, is say, Commission, you can't take this one element into consideration in setting the ROE and the capital structure, frankly. You cannot take the fact that a utility has been awarded or approved a decoupling mechanism and use that against them in effect. But all the other balancing that goes on, the customer interest, the economic conditions, the utilities, financial condition, all of those things are still fair game and still can be considered in the rate setting context. So I think it's important, to have that in mind and to realize that we're dealing with a really small element of the rate making process. The part that I address is section 6217(5)(f)(4), which provides that the commission shall not reduce the utilities' return on equity based on approval of a disincentive removal mechanism or profit incentives pursuant to the Efficient Use of Energy Act. And we submit that this language is plain and unambiguous and fully reflective of the legislature's policy to remove utility disincentives associated with energy efficiency and demand response programs under the EUEA. The Commission's interpretation of subsection 5(f)(4) pays lip service to the mandate that a utility's return on equity or ROE cannot be reduced, but in actuality, its interpretation renders this subsection meaningless. And that's because that the Commission purports to reserve to itself the right to make adjustments to utilities' capital structure and weighted average cost of capital or WACC in a manner that allows the Commission to bypass the statutory restriction against reducing a utility's ROE. The parties supporting the Commission's interpretation argue that because the subsection 5(f)(4) doesn't specifically mention WACC or capital structure, that the Commission is free to adjust these utility cost elements based on approval of a decoupling mechanism. And this argument ignores that the return on equity includes two linked elements. The first is the return or profit, and the second is the equity, which reflects the capital contribution of investors. And a utility's capital structure is typically made up of equity and debt. And the cost of debt is usually tied to the actual cost or the interest rates on that debt. And the equity portion of utility's capital structure.
In this case, in the posture we're in right now, do we even know whether there will be a reduction in ROE?
Well, we know that the Commission believes that it has the authority to reduce, in effect, reduce the ROE based on adjustments to the capital structure.
But we haven't seen it yet.
We agree that it hasn't been specifically applied, but the Commission
So
has.
then is that an advisory opinion from this court, or in other words, is this issue even right? I think, to my mind, we have to decide the primary, what I think of as the primary issue, under 5(2) first, and then we see what happens with respect to your argument, because we don't know yet what that looks like.
I certainly agree that the overarching issue is the issue that was addressed by Mr. Marks. However, a subset of the issue before the court has to do with the impact and the ability of the Commission to reduce the ROE based on a decoupling mechanism. And I would submit that under the posture of this case, where we're just looking at the bare statute, if you will, the statutory language and interpreting it, that this case is ripe for determination. I mean, the Commission has the authority to give a declaratory order, a declaratory judgment, if we're looking kind of at
But it seems like under the present circumstances, all we could say is the statute says what it says. And as far as any factual basis or whether any facts fit within that or don't, we don't have a record.
Well, I agree with you, Justice. We would like for you to say the statute says what it says. But we do know that the Commission has gone I think, in our view, beyond what the statute says, and says that we can impose, if you will, a hypothetical capital structure, which in effect reduces the ROE. And I can give you an example.
So are you talking about when they want us to steer away from the plain language and they talk about absurdity and the impact full decoupling would have? Is that what portion, or are you actually talking about the application of the record in this case? And I just want to clarify, because I think that's going to kind of our questioning.
No, absolutely, Justice. What we're really talking about is, what does the language say and what does it mean? And we think the language is very clear that you cannot, if you approve a decoupling mechanism, you cannot, on that basis, reduce the ROE. And the way that is accomplished, if the commission wants to change the capital structure, for example, you've got a capital structure that's $50 million, you've got an ROE of 10%. That's $10 million that you would have your cost of service. If the commission goes in and decides, well, we're going to impute to you a capital structure of only 40%. Now that 10% applied to the 40% or $40 million
Smaller.
is 8%. So they have in effect reduced the ROE.
Thank you, Mr. Alvey.
So thank you very much.
Thank you. Nanasi.
Good morning. My name is Marilyn Assey. May it please the court. I'm representing New Energy Economy, and I'm here to answer questions and address arguments made by intervening parties in their briefs. I'd like to first respond to lawyers for the opposite side. I think that Mr. Marks was arguing about the earlier application, not the declaratory order in this case. There is no question that PNM has argued that there can be no adjustment. And their quote was, for whatever the cause, whatever the reason, and that's at 7 RP 968. And so,
But how does that position lead you all to believing that we can have limited or partial recovery? Because let me tell, statute does not use that language. So how are you getting there?
because to interpret the F2 in, the appellants want to interpret F2 in a vacuum. They don't want to see it contrary to this court's rulings, which is you read the entire statute.
But that doesn't answer the question I'm driving at. Just because that's what they want doesn't mean that's what we're gonna say. And because that's what they want but that doesn't mean that the statute doesn't say what the statute says. You know, where are you getting limited or partial from F2? I understand that one exists and we're reading it in pari materia. But that doesn't mean, well, if that's what they want, then we're gonna ignore 2, give added emphasis to 1 and say limited or partial.
We don't want you to ignore F2. We want you to actually apply F2, but it's narrowly tailored. And what's it tailored to? Regulatory disincentives. By whom? The utility. For what? For energy efficiency and load management.
I agree with all of that, but what into, to your mind, like use the language, what into suggests that it can be limited or partial?
Because without regard, if it were without regard and to be interpreted the way that the appellants want, then it would not allow the balancing that full.
I completely disagree with that position. F1 says balances public interests, consumer interests, and investors' interests.
But there's
2 says full. Those 2 can live together. And in fact, I think they should live together. You start with what they claim full to be, and then you do the balancing. But rather, PRC here says, we're not gonna start with full, we're gonna start with something even less than that, and then do the balancing. How is that consistent with the statutory scheme set forth by the legislature?
because in reality, what happens is this. PNM comes in with a rate case. They said, this is the energy efficiency and load management programs that we're going to expect in the next rate case. the PRC gives them that rate, let's say. And to your point, let's say it's 100. And then the PRC comes in with a petition for a rate making adjustment. Well, they're only gonna come in if they have overperformed. This is exactly what the legislature wanted. Hey, we're gonna give you an incentive. If you overperform, you do even better, we're gonna give you the difference. So you reduced sales even more than you expected. So we're gonna give you that difference. And that difference, that's what this is about. That's what this section is about. In that case, you get the full amount of your overperformance for energy efficiency and decoupling.
Is that what you're partial decoupling, what you're describing now, or is that full decoupling?
No, that's partial decoupling because it only affects,
That's what it only affects the difference.
it
that you're
only
talking about.
affects the difference. But if they underperform, and they underperform for weather because it's a mild summer, or they underperform because of COVID, or they underperform because new tax code comes in, or anything else, they don't get it because it's not a utility program, and it's not a regulatory disincentive. It's just a vicissitude of the market.
So are you saying, I just want to ask this I want to turn this on its head a little. Are you saying F2 does not allow the PRC to approve full decoupling? I know you're saying it allows them to approve limited and partial, but are you saying it does not allow the PRC to approve full decoupling?
Yes,
Okay.
and
assuming we don't agree with you, assuming that we believe the language of the statute does allow full decoupling, do you think this court can even go on past that analysis? In other words, do you think the other issues are ripe at this point?
I think that you can address the other, I agree with P&M. I know it's a shock, that you can determine what F4 means. And that would be helpful. But the reason we think that full decoupling is not possible is because in that, it's essentially a true up of their energy efficiency and load management programs. If in that true up, they can't take into consideration, well, why are the lost revenues here? That's why. And we're saying, wait a second, is it too old, like Mr. Marks had said? Is it because of
That's available in one. I think, I mean, this is just me, I'm not speaking for the court. This is just me. I think the PRC abdicated its own responsibility in this case to give life to one. I think 2 says full, and then that the PRC gets to come in and look at it and say, is this for something that's not viable, valuable, is outside of the balance of public interest, consumers, and investment. But it doesn't mean you start with a smaller number and then reduce it even further based on that balancing, which is what you just argued to me.
Can I add to what the chief just said? Your argument goes contrary to this court's decision in the Attorney General versus PRC case. That's the case decided in 2011, written by Justice Cerna, which says you have to, in setting the rate, take into account the factors in subsection 1. Comply with everything else. What am I missing?
I think that absolutely what the commission did in this case is follow both the 2011 and 2013 Attorney General versus PRC case, which is why I think they have specialized expertise to understand this. And I agree with you. I do think
that would apply to full decoupling as well.
It could in theory, but that's not what I think is in this statute. What I think is true, what you say is, yes, it requires full balancing, and it requires 3 other things. One is utility-specific analysis. The other is cost-based and evidence-based. And I think that that is absolutely true and can only be done if this is interpreted as this only applies to utility-specific decisions regarding regulatory disincentives, regarding load management and energy efficiency.
The
Not
language,
anything.
the language, as the chief has repeatedly, I think, pointed out, the language of F2 doesn't get you there.
I just think that the legislature, if we want to look at as Marbob Energy versus New Mexico Oil Conservation, what we're talking about, it says is we need to look at the full statute and then include the analysis with the Public Utility Act. And the legislature didn't say, oh, utilities, you get your revenue requirement bar none. It said, we're dealing with the energy efficient use of energy. And that's what this section is about. And
But Mr. Marks made the same point that you don't get, just because you submitted it, you don't get what you, the commission doesn't rubber stamp.
well, I think that this interpretation by the commission, which I believe is correct, based on their specialized knowledge, is that it would be a rubber stamp. It would remove the
I don't think
balancing.
their specialized knowledge is in statutory interpretation. I think that's our specialized knowledge. So hanging your hat on regulatory specialized knowledge is not helpful to the task at hand, which is statutory interpretation. So what in the statute says you start with something less than full before you begin the balancing of the public interest, consumers' interest, and investors' interest? What in F2 says that?
I think that what it says in F2, if we can go look at it, is that this pertains to regulatory
I don't
disincentives.
disagree with you, but it doesn't mean you start with kind of this idea. It almost seems arbitrary to say instead of 100, we're going to start at 50 because that's what regulatory disincentive tells us to do with limited and partial. This says start with full and then examine it. So the discretion for the PRC is in the then examine it.
If that's your interpretation, that's akin to what we actually believe. But that's not what PNM's interpretation is, which is, excuse me, please.
No, I'm sorry, I just want to make sure I'm following you. So although our expertise is statutory interpretation, it's not utilities, so excuse my probably misstatement, but the full decoupling would involve something more than just regulatory disincentives, whereas partial decoupling includes all regulatory disincentives.
All disincentives,
All disincentives. So,
not regulatory even.
but I mean, the partial would be, so that's why you're arguing basically that if it involves regulatory disincentives, then it can be decoupled completely. But if it doesn't, it cannot be decoupled.
And that it has to be a utility program. It has to be a utility program. So if I get solar on my house, but the utility didn't make that happen, then no, their loss of sales, they don't get that automatically back. Or if there's some other reason
Like
that,
weather.
like weather, like a tax reform, like COVID, like blackouts.
So you're really hanging your hat on the regulatory disincentives language in subsection 2.
And also at the end of subsection 2, it talks about commission-approved energy efficiency and load programs. So what they would do is, if you go to then the first part is after, in a rate case, a customer rate is decided, then they come in and they say, okay, we performed better than we expected. We'd like we'd like even more revenues. And then if that is true based on energy efficiency and load management, they get it. But if they don't, if they didn't make as much money because of something completely different, they don't get it. That's the difference. I want to just point out to you that Mr. Alvidra said, this is not a sea change, it's just a small element. So the evidence in this case was that it was just going to be a $15 million hit. But that's not the question. The question is it legal? Will this result in just and fair and reasonable rates? And will that balancing happen? Can the commission come in and look at the specific differences in the revenues? What are those? Is it because is it so old in 2015? Is it because of taxes? Is it because of all those things? Or is it because of your efforts at reducing conservation? Because the legislature didn't intend them to get their revenues no matter what, which is their position. That's why it's absurd, their interpretation. I'd like to move on because I have 1 minute left, and if I could just refer you to something completely different, which is another part of F4. I think that Your Honor asked about the plain words. Mr. Alvidra said, yes, just impose what it says. After Judge Vigil, you asked him, if that's what you do, that's what we ask you to do on that. However, New Energy Economy has raised the question before this course of the unconstitutionality.
Where did you raise it?
We raised it down below, and we raised it,
Did you follow appeal on that?
we didn't file an appeal on it.
And when did you raise it?
It every,
In your answer brief, correct?
yes, but we
Here's
also.
my question. In 8 seconds. You're raising you're challenging a statute on constitutionality and answer brief in which you never appealed. Tell us how, as a high court, we should deal with that in that procedural process.
I think
You are
that
challenging a state statute as unconstitutional in an answer brief without an appeal, which we see a lot in these kind of cases. How should we handle that procedurally?
it was raised.
Should we get the state, did the state take a position on whether the statute's constitutional?
I
have
don't,
the Attorney General's office over there.
I don't believe that they did. And so the thing is that under Duquesne and Duquesne, excuse me, and the Attorney General versus PRC in 2013, NMSC 42, section 16, or paragraph 16, and Duquesne 488 US 299 at 316, which says the designation of a single theory of rate making as a constitutional requirement would unnecessarily foreclose alternatives which could benefit both consumers and investors.
Ms. Nanasi, your time is up and you're not addressing Justice Thompson's question. So I'm going to cut you off. Ms. LaCote.
Good morning, and may it please the court. I want to go back just a little bit to what the commission thinks this case is really about. And it's really the question, I think, before the court is whether subsection F2 mandates full decoupling. So whether it's a partial decoupling or full decoupling is not, I mean, the commission made its decision, but the real question is whether the statute mandates the commission to do something. And I think that's where the requirement of reading into the subsection 2 of the balancing requirement that the commission has to do in order to reach just and reasonable rates comes into play. And I want to look at the statute because I think, Justice Bacon, I think I can answer your question going on what Ms. Nanasi said, that this if we look at subsection F2, commission shall, upon petition by a public utility, remove regulatory disincentives through the adoption of a rate adjustment mechanism. And so it's really important that both the commission and this court look at both parts of that. And the commission has to adopt the rate adjustment mechanism described by the latter part of the sentence, but again, only to the extent that it removes regulatory disincentives. And Justice Zamora talked about this, that there's a difference between a regulatory disincentive and something extraneous like weather. But the commission has to have the ability to examine what the regulatory disincentives are and then determine what is necessary in order to remove those disincentives. So the question of whether the statute mandates the commission to accept full or partial decoupling The answer to that has to be no. There can't be any mandate here. The commission has to have some discretion in determining what is in the petition that is placed before it, determining whether those are regulatory disincentives, determining what is necessary to remove them if they are, and then ensuring that those that results in a just and reasonable rate. So under a plain text reading of the statute, the question is, that the statute doesn't mandate the commission, but then also looking at prior history of statutory interpretation for the commission. There are two cases in particular, and Justice Vigil mentioned one of them, and it's the Attorney General versus PRC in 2011, where the commission didn't do the balancing test. And this court said specifically, a commission, in order to interpret a statute, you have to look at the statute and harmonize within the context of the remainder of the Efficient Use of Energy Act, and then also harmonize in context with the remainder of the Public Utility Act. And then in 2013, in Attorney General versus PRC, which is 2013, Supreme Court 42, this court upheld the commission's interpretation of their statute because it read the statute in harmony with the remainder of the Efficient Use of Energy Act and the Public Utility Act, and it followed the guidance from this court in the 2011 matter. And this court also found that the Efficient Use of Energy Act gives the PRC authority to eliminate financial disincentives to energy efficiency and load management measures, which means when read in harmony with the remainder of the Efficient Use of Energy Act, that Section F2 must give the PRC authority with respect to financial disincentives. Yes.
I hear what you're saying, but I don't think what's turned this on its head is saying we're going to go with limited or partial and then not do the balancing at all, because if we go with limited or partial, no balancing has to happen, which is actually the opposite of the Attorney General case. So talk to me about that, because the commission here appears to have attempted to determine the rate without that balancing by going to something that's less than full. Whereas I think it should be starting with the idea that it's full, and then you examine what they've presented and make decisions under F1 and all of the prior precedent after that. So it seems like it's turned on its head.
And I agree with you, Justice Bacon. I think that I think that, again, the question of partial and full is not really the issue. I think it's being muddled here. It is possible that the commission got this wrong in its recommended decision and its order. But really, the question is that the commission has to have the authority somewhere to look at this.
I don't disagree with you on the commission has the authority. I mean, the statute says the commission has that authority. But it's like, you asked for 100 and you said, well, we're not going to exercise discretion, so we're going to start at 50.
Yeah.
And that to me is the rub here. It should be PNM, you present whatever you present and it's this big, and then we're going to use our authority under one and all of our prior precedent to assess whether it's fits within that regulatory disincentive or not.
Right. And
that would be consistent with the policy set forth by the legislature in 62-17-3.
Yes, I agree. I think that the way that the hearing examiner went about trying to get to this point kind of looks at full decoupling as what, I don't remember, I apologize, I don't remember who brought it up earlier, but looks at full decoupling again as a blank check. And if that's the interpretation, so I think that's where the commission was looking at this, that that the commission is mandated to do full decoupling, and that is not what the statute says.
The IC hits, they want to, that's how the commission viewed it. But then it's like they back-ended in this weird way, and they think their discretion works.
And well, so that's really the question. If you look at the way that the commission came to this partial decoupling answer, it was to ensure that the commission, again, I don't want to sound like a broken record, but it's to ensure that the commission has some authority to look at.
I find it fascinating that nobody argued. It's just that
examiner who came up with this, but that's just an aside.
I do, so I, you know, looking, so there's a plain text analysis that I think we all agree gets the commission some authority. There's reading the statute in harmony with the remainder of this, of the Efficient Use of Energy Act and the Public Utility Act, which gives the commission authority. So I think the question of whether subsection F2 mandates full decoupling has to be no.
But but if we look at the PRC's order below, it's not that it mandates full decoupling. It seems to me the PRC was saying, we can never approve full decoupling. And just based on the actual order, that seems to be a little different than what you're saying today.
Right. Well, and I think, and that's another question, right? To the extent that the commission is required to accept a full decoupling petition is kind of the overarching umbrella question. And to the fact that it can never, so I apologize. So if we back up and look at this, if the commission has no authority to exercise any of its discretion and it just has to accept it, then that interpretation can never happen because the commission has to have some authority, right? But if there's a way that you can look at a full decoupling petition, have the commission examine these regulatory incentives or disincentives, and then make a determination there, then no, it is possible to accept some full decoupling petitions and reject some full decoupling petitions.
It sounds to me like you, Mr. Marks, and Mr. Alvidrez, you all agree.
It does sound like that, doesn't it?
So you get to the meat of the case probably.
Right.
So, but what do we do with the order as written? Don't we have to vacate it? Because as written, it seems to suggest that the PRC will never approve full decoupling.
So,
Yes.
so,
yeah.
and so I think that's the thing, is getting tripped up on whether it's full decoupling or partial decoupling. And I don't think is really the question. I think if the PRC has an opportunity to examine a petition and the PRC has done its balancing requirements and has come to the conclusion that, you know, they've identified the regulatory disincentives, they've determined what's necessary to remove it. If that petition is full decoupling and the PRC says that that's okay, then that's okay.
But the order here basically assumes that full decoupling will never happen. And that's not consistent with the statute either. And in fact, it's not rubber stamping, but it's starting from the premise that, I mean, P&M could submit for an adjustment that is fully consistent with the statutory language and is supported and is fair. And the way this order is drafted is, nope, we're still gonna take something off the top no matter what, because we're only gonna give you part of it.
So I
think it's bad, pretty bad drafting. But doesn't this beg for vacating it, sending it back and saying, do the fact finding that you're supposed to do?
I don't know if it begs for that. If this court decides that that's what it wants to do.
You don't have to agree with that.
If this court decides that that's what it wants to do, the commission will look at it, of course. I don't know that it's necessary to vacate this because, again, I think that the way that the recommended decision and then the order was drafted was it looked at that statutory language and it said, again, it doesn't have to mandate that the commission accepts this petition, that there has to be something. And again, if we look at those two pieces of the statute, that the latter part, there is a rate adjustment mechanism described in the latter part of that sentence, only to the extent that it removes regulatory disincentives. And that's, yeah.
But I don't think that's what the order does here.
Okay.
I think that's why, to my mind, that's why we're here, is the order goes much further than that and suggests that it will never happen. Which then is also a lack of exercise of discretion by the commission.
That is true. That's absolutely true.
For example, paragraph 21 of the order, the commission's order, for an example, it says, indeed, the adoption of full revenue decoupling would be a radical departure from the regulatory paradigm established in the PUA, eliminating ordinary business risks to which public utilities are subject. So I think that's the point that the chief was making, so.
Yes, so, and I think that, again, I hate to keep saying this, but I think that it's really important that full decoupling without the commission's ability to,
Can I correct you there? It's
yes,
not ability, it's requirement to do that, consistent with the
Yes.
statute and the
Yes.
case law.
yes,
They're required, not
yes.
that.
Justice Wheeler, you're absolutely right. So yes, let me rephrase that. Adoption of a full decoupling mechanism that removes the commission's requirement to balance these interests and to come up with a just and reasonable rate cannot stand. And I think that that is what would be a radical departure from the regulatory paradigm. And as long as what the interpretation of the statute doesn't require the commission that doesn't mandate full decoupling without looking at those other pieces that the commission is required to look at, then I think it's okay. So I think that that's really the key language here, is that it can't be mandated and the commission has to have authority to do this balancing test and to establish what the regulatory disincentives are and determine whether they need to be removed.
I'd like to ask this question because I can use the term whack. It seems there's that second issue appeal from PNM. New Energy Economy, I don't want to misrepresent, said there'd be some clarification would be helpful. I do agree with my colleagues, but I think we all agree there's a threshold question and statutory interpretation. What is your view on the need to get to the second issue, again, given the procedural process of these cases, and to try and avoid ping-ponging?
Justice Thompson, I agree with your question earlier that I don't think that this issue is ripe before the court because the order and the recommended decision didn't actually say amend the WAC or the return on equity.
Did, in your view, the commission come to a legal conclusion about whether that is possible or not?
I think it's, yes. But I think, again, if you look at the language of the statute doesn't actually say WAC. The statute says the return on equity. And you have to look at those two pieces that, the utilities know that those are separate entities because we just heard argument about that. The commission knows that those are separate entities, and we have to presume the legislature knows they're separate entities. The legislature didn't include WAC in that statute. So, thank you very much.
Where are we?
Hey, this has been interesting. And I think I know a few things that the honorable bench doesn't know because you haven't done a rate case or one of these cases. And you can cut me off at any time, but I want to explain that Ms. Nanasi mentioned PNM was coming in for $15 million with this adjustment. I don't think that's correct. This is not the kind of a case where PNM is going to come in next year and say, we want $50 million or $5 million for decoupling for what happened last year. What's going to happen is PNM or another utility that wants this is going to file a rate case, just like I'm in a rate case right now with PNM. And I'm actually aligned with Ms. Nanasi in that case. But they're going to come in and there's going to be a bunch of calculations, what the costs are, what the return on equity. At the end, they're going to come out with an approved revenue requirement. And you're going to divide that by the number of kilowatt hours in each class that you expect to sell during the future test year, which is something the legislature told the PRC to do. And I didn't like, but the legislature said do it. So we do it, or they do it. And so you're going to divide the revenue requirements by the number of kilowatt hours. And then if we have full revenue decoupling and PNM asks for it, or they're going to say, how much is that per customer? And might turn into $55 a month or something, and you're gonna set that as the base period amount, and a year and a half from now, if it turns out it was $54 per month, there's gonna be a mechanism that says we're gonna collect that extra dollar. And if it turns out to be $56 per month, there's gonna be a mechanism that refunds a dollar or credits a dollar to customers. And it'll be a mechanism.
No matter why that difference exists. So it could be whether somebody buys solar, somebody dies.
Probably not somebody dies because it's a revenue per customer, but yeah, if they were, and it's a vacant house,
Yeah,
that happens all the time.
Missing, so you're saying, so then what you're saying is consistent with the respondent's concern that your client thinks they can recover for any variable, regardless of its relationship to regulatory disincentive.
Yes, Justice, and my client is not P&M, but the legislature wanted a system.
Regulatory disincentives mean?
There's a regulatory disincentive. The utility has an incentive to sell more kilowatt hours. And there are some things they may have control over. For example, one of the things that always concerns me is you've got this program and we're looking at, and here's they're saving money here. And they can be doing something outside the program to increase sales. They could have a program that looks like it's, because we don't actually measure, you don't go into customers' homes. They're sampling, it's complicated. They have a program that does well on the test, but doesn't do well in reality. The legislature
But the petition that P&M filed was for, it went beyond regulatory disincentives,
it
which is
did.
why it was full decoupling, right? It went beyond, yeah.
P&M wants to recover for literally every
Thank you.
variable that they didn't anticipate that means that there's less money in their pocket.
Or refund. Again, it's symmetrical.
I get
It's
that,
not
but
a-
if we're just doing the symmetrical, some years they're up, some years they're down, and pound sand, then there is no discretion in the PO.
Justice Bacon, Chief Justice, there is discretion. There's discretion to, if the thing is, it's a rigged game, if it's the scenario Ms. Nassi mentioned or I mentioned where P&M always wins, the commission needs to reject that. They need to tell them, reapply. But if it's done right, we expect it to be zero. We're projecting, and then if there's more savings, there's an adjustment.
So
And-
how does that live, so in F2, giving all words meaning, what does regulatory disincentives mean and how does that modify the rate adjustment?
And the legislature made that decision. The legislature
What does
said,
it mean? The legislature can put words on a piece of paper all day long and we're left to interpret it. So how do I give effect to both regulatory disincentive and rate adjustment mechanism?
and with all respect, the legislature said this is a mechanism to remove regulatory disincentives. They used those words in F2. They said you should remove it by doing full decoupling
That's not
because
what it says that.
it says shall, and it says this is a regulatory disincentive, and Justice.
But regulatory disincentives, how is the weather a regulatory disincentive? I'm gonna use that really basic hypothetical that's been presented to us.
It is not, and
So how do you recover for the weather?
because the legislature decided that
No,
those
the
side effects.
legislature says it's removing regulatory disincentives, and if the weather isn't a regulatory disincentive, we're not
You don't
gonna,
get it.
we're not
But-
gonna adjust the rate.
But the legislature allowed that it's a side effect. It's a side effect of this mechanism, and it was an acceptable side effect because it doesn't prejudice either side.
The sentence starts with remove regulatory disincentives through the adoption of. I mean, it's starting with the whole idea, the whole premise is to remove regulatory disincentives, and then they're telling us how to do it. So isn't it limited to regulatory?
Justice Zamora, this mechanism, decoupling, is shown in other states to be a very effective way of aligning utilities incentives with the state policy for conservation and efficiency. It takes away the utility's ability to earn a profit by selling more kilowatt hours, and takes away their incentive to do that. And the legislature could very well have decided it is worth taking away that incentive, even if it has side effects, because the side effects, there's nothing wrong with them. It goes up and down for weather.
But wouldn't they have said remove all disincentives instead of remove regulatory disincentives? If they meant to remove all disincentives like weather and
Well,
people who die and stuff?
Justice Amora, that's not a disincentive. We'll be honest here. That's just,
That's not a
it's an
disincentive.
extrinsic
I guess I
factor.
should have said, well, I just don't understand why they put those words there.
They,
Why doesn't it just say upon petition by a public utility, you can adjust the rate fully?
Justice Amora, I've never been a legislator, but I don't know. But my speculation is they put that in there to avoid the argument that this is doing more than removing disincentives. The legislature said, this is an option for removal of disincentives. You don't have to do it, but if the utility applies for it, and you don't have to rubber stamp it, I want to be very clear. If it's a rigged game, you don't have to approve it. But the legislature was okay with weather flowing in this because the benefits of doing this are otherwise so good, of severing the tie between sales and profits. Many states do it. The states that do it have better results than the states that do the partial approaches, which is what the pre-2019 law was. The law, prior to this amendment, you could do everything that appellees would say is okay. The legislature, this court has to give some effect to this new amendment. And the plain language, it's very hard. This is not, there was a case, I think it's Maestas, where this court found that the Government Conduct Act didn't reach judges, and that just seems offensive to all of us, but that was what the legislature wrote, and there was no indication that they had a drafting error, unlike some other cases. There's no evidence here that the legislature did not understand that they were throwing in weather when they also took away that utility incentive for profit. And there's nothing unfair about it. As we explained in our briefing, it goes both ways. It's not a big adjustment. The legislature has severed the connection between profits and things beyond our utilities control in other contexts. And I would just urge the court to, I can see the court agrees that there's something done here and there still needs to be balancing. I agree, but the balancing can't be, you do some, has to be within, you have to find a balance and find a result that still gives effect to these words, and the commission still can do that. And I'm sorry. And
It's a tough case.
it's, thank you. They always are, they wouldn't be here.
Yeah, exactly. Thank you. All right, thank you, council, for all of your various arguments. The case is